My brother didn't hug me at my father's funeral. He stood 3 feet away and watched me like he was calculating something. Not grief, not loss, something closer to inventory. I noticed it, but I didn't say anything. We had just buried the man who raised us both. I told myself it was his way of processing. I told myself a lot of things that week that I later had to unlearn. My father passed on a Tuesday in October, quietly, in the bedroom of the house he had lived in for 31 years. I was there. I had been there most nights that final month, sleeping on the pull-out couch downstairs, making sure his medications were sorted, that the overnight aide knew his preferences, that someone who loved him was close by. My brother was not there. He had been in Phoenix for a conference. Then he extended it by 4 days for what he described to me over the phone as necessary networking. I didn't argue. I just stayed. My father and I had always been close in a way that was quiet and specific. We didn't talk a great deal. We sat together. We watched baseball. We drove to the hardware store on Saturdays for reasons that were never entirely necessary but always felt like something. After my mother passed 6 years before him, he and I fell into a rhythm that sustained us both through the years that followed. My brother had his own life, his own priorities, and we all made our peace with the shape of things. My father updated his will 14 months before he died. He did it with full awareness, full deliberateness, and full legal counsel. I know this because I sat in the waiting room of the attorney's office while it happened. I did not go in. I did not ask to go in. He told me he wanted to handle it himself, that it was his business to sort, and I told him I understood and went to get us both coffee from the place down the block. When he came out, he looked lighter somehow. He squeezed my hand in the parking lot and said, "Everything is how it should be." I didn't ask what he meant. It was his life. It was his decision. He left the house and the majority of his estate to me. He left my brother a specific sum, a meaningful one that most people would consider significant. But it was not the house. It was not the savings account that had accumulated quietly over decades of my father's careful, unhurried life. And it was not equal. My brother found out 3 weeks after the funeral, when the attorney read the terms. I watched his face in that office. I watched something shift behind his eyes, something that had been waiting for a place to land. He didn't say anything in the room. He thanked the attorney. He shook my hand. He walked out to his car, and I didn't hear from him for 9 days. When he called, his voice had changed. It had taken on a certain flatness, like he had rehearsed what he was about to say enough times that the emotion had worn off it completely. He told me he had spoken to an attorney. He told me he believed the will was not valid. He told me that our father had been vulnerable in his final year, that I had been present in a way that created undue influence, that a man in declining health could not reasonably be said to have made fully independent decisions about his estate. I listened to all of it. I didn't interrupt. When he finished, I said, "I understand you're hurting." He said, "This isn't about hurt. This is about what's right." And then he told me he would be filing a contest. I called my own attorney the following morning. The months between that phone call and the court date were long in a way I hadn't anticipated. Not because I was afraid of what would come out in court. I had nothing to hide. I was quiet during those months because I was doing what I had always done, paying attention, keeping records, and preparing for a conversation I hoped we would never have to have, but knew we probably would. My brother's attorney sent a series of letters. They were formal and aggressive in the way that attorneys' letters often are when the underlying case is weak and the strategy is pressure. The letters used words like manipulation and diminished capacity and undue access. They painted a picture of an elderly man being slowly isolated from his son by a daughter who had positioned herself as a caretaker in order to control his decisions. Every word of it was a version of my life that I didn't recognize, told by someone who had not been there, assembled from a narrative my brother had constructed in the 9 days he didn't speak to me. I read each letter once. I filed them. I did not respond emotionally to any of them. Not to my brother, not in writing, not to the mutual relatives who began calling me to say they had heard things and wanted to understand. I said the same thing to all of them. I'm not going to discuss this outside of the appropriate setting. Some of them thought I was being cold. I wasn't being cold. I was being careful. The hearing was scheduled for a Thursday. I arrived early. I sat in the hallway outside the courtroom and drank water from a bottle and watched people move through the building the way people always move through courthouses briskly, with folders, with that particular expression of someone managing something they did not choose. My attorney sat beside me and reviewed notes. I had given her everything she needed months ago. There was nothing left to review that she hadn't already memorized. My brother arrived with his attorney 11 minutes before the start time. He was dressed well, as he always was. He had always been the one in the family who understood presentation. He wore it like a form of argument. He glanced at me once in the hallway and nodded in a way that was meant to communicate something authority, perhaps, or certainty, and then he looked away and spoke quietly to his attorney near the water fountain. I watched him and felt something I hadn't expected. Not anger, not grief, exactly. Something more like recognition. I was looking at a version of my brother I had been slowly becoming aware of for years. The version that existed when something he wanted was not within reach. When they called us in, I picked up my bag and walked into the room. The judge was a woman in her late 50s with reading glasses pushed up on her forehead and the particular patience of someone who had heard many variations of the same story. She reviewed the filing summary while the room settled. Her clerk sat to her left. My brother and his attorney were at the table to my right. His attorney opened. He was practiced at it. That specific combination of gravity and momentum that moves a room into a particular frame before anyone has had a chance to question the frame itself. He spoke about my father's health in the final year. He spoke about the frequency of my visits. He spoke about isolation from family, by which he meant my brother, and about the nature of influence in relationships where one party is dependent and the other is present. He used the word vulnerable 7 times. I counted. He said that a man of compromised health, living alone, relying on one child for daily support, could not reasonably be said to have exercised fully independent judgment when revising a will that substantially benefited that child. The judge listened without expression. When he finished, she looked at the filing and asked a question. What is the medical basis for the claim of diminished capacity? My brother's attorney said that while there was no formal diagnosis, the circumstantial pattern of dependence and isolation was consistent with conditions that impair independent decision-making. The judge looked at him over her reading glasses. Circumstantial pattern is not a medical basis. What documentation do you have? He referenced my father's age, his general health history, a prescription for blood pressure medication. The judge set down the paper in her hand with a quietness that carried weight. Blood pressure medication is not evidence of cognitive impairment. Do you have a physician's statement, a neurological assessment, any clinical record indicating diminished capacity at the time the will was executed? He said they had not yet obtained such documentation, but that discovery would. The will was executed 14 months before the deceased passed away, the judge said. That is not a recent revision made under distress. What specifically indicates that the deceased did not understand what he was signing on the day he signed it? There was a pause. My brother shifted slightly in his chair. His attorney said that my presence in the home created an environment in which independent decision-making was difficult to establish. The judge asked him to explain what he meant by difficult to establish. He said that given the circumstances, the influence was implied. Implied, the judge said. Yes, Your Honor. She wrote something on the paper in front of her. The room was very quiet. I kept my hands folded on the table and looked forward. Then the judge turned to my brother directly. She asked him how frequently he had visited his father in the final year of his life. My brother said he had visited as often as his schedule allowed. She asked him to be specific. He said he believed he had visited 3 or 4 times. She asked whether he had ever discussed with his father his wishes regarding the estate. He said they had spoken about it generally. She asked whether he had ever been present at any meeting with the estate attorney. He said he had not. She asked whether he had received any communication from his father in the final year, letters, emails, phone calls in which his father expressed dissatisfaction with the will or indicated he had been pressured in any way. My brother said his father had not communicated with him directly about the will. The judge paused. Your father didn't tell you he felt pressured? No. Your father didn't express concern about the distribution of the estate? Not to me, no. But you are claiming that the will does not reflect your father's true wishes. My brother said yes. He believed that to be the case. The judge looked at him for a long moment. Based on what? His attorney stepped in again. He redirected toward the issue of my access, my presence, the structural imbalance of a situation in which one child is the primary caretaker. He said that courts had a responsibility to look carefully at estate revisions made under these kinds of conditions. The judge said she agreed that courts took these matters seriously. She also said that the burden of proof rested with the contesting party and that the contesting party had thus far provided no clinical documentation, no correspondence from the deceased indicating distress, and no witness testimony from anyone present during the will's execution. She looked at my attorney. My attorney stood. She was calm in the way that people are calm when they are standing on solid ground. She said that we had documentation to enter into the record and asked permission to proceed. The judge said yes. My attorney submitted the first item, It was the letter my father had written to the estate attorney 14 months ago, in his own handwriting, outlining his intentions and his reasoning. In it, he wrote clearly, in sentences that were his specific, a little formal, utterly recognizable, that he had made his decision with full awareness, that he wished to provide for his daughter in recognition of her years of presence and care, and that he wished to provide a specific sum for his son, whom he loved and who had built a life that did not require the house. He had used the phrase, does not require the house, about my brother. I had not known he wrote that. When I read it for the first time in my attorney's office, I sat very still for a while. The clerk read portions of the letter aloud. My brother's attorney leaned toward him, and they exchanged something quietly. My brother's jaw had tightened. He was looking at the table. My attorney submitted the second item. It was a notarized statement from the estate attorney who had prepared the will, attesting that at the time of the signing, the deceased had presented as fully oriented, engaged, and clear in his instructions. The attorney had noted in his file that the deceased had come alone, had prepared written notes in advance, and had declined any assistance in drafting the document's language. He came alone. He prepared notes in advance. I had not known that either. I thought about the parking lot, the way he looked lighter when he came out, the way he squeezed my hand. The clerk read the notarized statement into the record. My brother's attorney made a procedural objection. The judge addressed it briefly and overruled it. Then my attorney submitted the third item. She described it to the court as a video file recorded on the day of the will signing by the security camera in the estate attorney's waiting room, standard practice in the office, standard disclosure in the client agreement, and that it had been preserved in the attorney's records as part of the file. She said she had obtained it through proper discovery channels and that it was being offered to establish the state of the deceased's presentation on the day in question. The clerk set up the monitor. My brother's attorney said he would like to review the footage before it was played. The judge said he would see it when the court saw it. The footage was not dramatic in the way that the word footage sometimes implies. It was quiet, grainy, in that particular way of waiting room. Cameras overhead, angle, timestamp in the corner, the muted palette of a professional office. My father walked in at 14 inches the morning. He was using the cane he had started using that year, the wooden one with the brass tip that he had initially resisted and then grew fond of. He spoke to the receptionist. He sat down. He took a folded piece of paper from his jacket pocket, his notes. I realized, the notes he had prepared in advance, and he reviewed them. He sat straight. He turned a page. He put the notes back in his pocket. When the attorney came to get him at 10:22, my father stood without assistance, shook the man's hand, and walked into the office with the measured steadiness of someone who knew exactly where he was going. The courtroom was quiet in a way that had a texture to it. The judge watched the footage without expression. When it ended, she removed her reading glasses and set them on the desk. She said, "The individual in this footage does not present as a person of diminished capacity. My brother's attorney said he would like to engage an expert to review the footage for signs of..." The judge said that she had seen the footage and that an expert review of a waiting room recording would not change the court's assessment that the contesting party had not met the burden of proof required to invalidate a properly executed will. She looked at my brother's attorney and then at my brother. She asked my brother's attorney if he had anything further to submit in support of the contest. He said he did not at this time. She asked whether the contest was being maintained or withdrawn. There was a pause. My brother's attorney spoke quietly to him again. It lasted about 30 seconds. My brother did not look at me during any of it. His attorney said that in light of the court's findings, the contesting party was withdrawing the challenge. The judge said she was noting the withdrawal for the record. She also said she was noting that the challenge had been filed without supporting medical documentation and without any evidentiary basis beyond the contesting party's characterization of his sister's caregiving role, and that the court found this characterization insufficient and the challenge without merit. She said that she was also referring the matter to the Bar Association for review of the conduct of the contesting attorney, given that the filing appeared to have proceeded to court without the documentation that would be required to meet basic evidentiary standards for a capacity challenge. That was the part I hadn't expected. I kept my expression still, but something moved through me. Not satisfaction. Exactly. Something closer to witnessing. I was watching a room correct itself. My brother's attorney said he understood the court's position. The judge said the estate would proceed to distribution in accordance with the will as executed. She gathered her papers. The clerk began organizing the submitted documents into the record. My attorney wrote something on her notepad and slid it across the table to me. It said, "We're done here." I picked up my bag. I stood. I did not look at my brother. Not because I was trying to make a point, because there was nothing left to say that the room hadn't already said more clearly than I could. In the hallway afterward, my attorney walked me toward the elevator. I asked her about the bar referral. She said it was at the judge's discretion and that it didn't guarantee any action, but that it was a signal. An attorney who files a capacity challenge with no medical documentation is an attorney who either didn't do due diligence or did it and filed anyway. Either way, she said, the judge had noticed. I asked her what came next. She said I would hear from the estate attorney within a few weeks to begin the formal transfer process. She said I should expect my brother's attorney to send a letter backing away from any further action. She said I should also be prepared for my brother to reach out, possibly through other family members, possibly through an intermediary, in the way that people sometimes reach out when they want to indicate they have moved on without actually saying they were wrong. She was right about all of it. The letter from my brother's attorney arrived 12 days later. It was careful and bloodless, 3 paragraphs that said almost nothing except that their client had elected not to pursue further action and wished all parties well in the resolution of the estate. It did not contain an apology. It did not contain an acknowledgement. It was the legal equivalent of someone leaving a room without looking back. My brother texted me 3 weeks after the hearing. He sent a single sentence, "I hope you're doing okay." I read it twice and then set my phone down on the kitchen counter. I stood there for a moment in the particular silence of a house that had not yet finished becoming mine, and I thought about my father reviewing his notes on a folded piece of paper in a waiting room, making sure he had not forgotten anything, making sure everything was how it should be. I didn't respond to the text that day. I made coffee. I sat at the kitchen table, my father's table, the one he had brought from the first apartment he and my mother had shared, the one with the small burn mark on the corner from an incident he always described differently depending on his mood. I sat with my coffee and I sat with the quiet, and I let myself feel the full weight of what had just been protected. Not the house, not the account, the record. The truth of who my father was, and what he had decided, and why. That was what had been at stake, and that was what the room had corrected. Some people will tell you that family is complicated, that you have to find ways to understand where people come from when they do things that hurt you. I don't entirely disagree with that. I understand where my brother came from. I understand the grief underneath the filing, the years of distance turned into something that needed a target. I understand that losing a parent can unhinge a person's sense of what they are owed by life. I understand all of that. What I don't do is confuse understanding with agreement. My father made his choices clearly and deliberately. He sat in a lawyer's office with handwritten notes in his pocket, and he signed a document that said what he meant. He was not confused. He was not manipulated. He was a man who knew exactly what his life had contained, who had shown up for it and who hadn't, and who loved both of his children in different measures that reflected nothing more and nothing less than the truth of what had been between them. He asked me once, about 2 months before he died, whether I thought my brother would be all right. We were sitting in the backyard in the evening. It was warm for October. He was watching the neighbor's dog move along the fence line. I told him I thought my brother would land somewhere good. I told him my brother was resilient, that he had always found his footing eventually. My father nodded. He didn't say anything else for a while. Then he said, "I want you to keep the table." I told him I would. He said, "The burn mark has a story." I told him I knew. He smiled at that. We sat there until it got dark. He went inside first. I sat for a few more minutes listening to the neighborhood settle, and I didn't know then that I was storing it, that moment, that light, that specific quality of ordinary evening. You never know when you're storing something. You only find it later, intact, in a moment when you need it to be there. The house closed into my name on the 15th of February. The estate attorney handed me a folder and shook my hand in a lobby that smelled like coffee and old carpet and the specific atmosphere of things being finalized. I drove home along the route my father used to take from the hardware store on Saturdays. Not the fastest route, not the most direct one, but the one that went past the park where we used to watch the geese come through in the fall. I took my time. The table is in the kitchen now. The burn mark is on the corner, facing the window. Some mornings I sit there with coffee and the early light comes in a certain way and I think about what it costs to be present for someone. Not the sacrifice version of that, not the martyr version. Just the simple daily cost of showing up, of being the person who stays, of choosing proximity to someone else's life when you could just as easily choose distance. It doesn't always get recognized. It doesn't always get named in the right ways at the right times. Sometimes it just gets filed in a waiting room camera and retrieved 14 months later by a clerk reading items into a court record while a room goes very, very quiet. My father knew what he was doing. He always did.